joining us, and for many of the faces on here continuing to join us for CASBA Summer Speaker Series. We're really happy to be sharing information with you today around surplus district property with our great partners here that we'll introduce in a moment. But before we do, I'm Tasha Davenport, Deputy Executive Director and Chief Operations Officer for CASBO. Thank you for joining us. We will be recording the session today, as we have with the entire speaker series, so find comfort in that you can kind of relax and pay attention and go back should you need. And we're also putting together really strong Q&A documents for you. So the flow will be that if you have questions, you're going to enter those into the Q&A area. Sarah and Christina are going to be categorizing those and getting the answers for you from our experts towards the end of our session today. And anything that we don't get to, they've done an amazing job of reaching back out to these experts, getting answers, and again, turning that back out so that you've got a resource on our website along with the webinar going forward. So that's enough of the logistics. Enjoy our executive director here at CASBO, and she can introduce our panelists today on this important topic. Thank you.
Good morning, everybody. And again, I would echo Tasha's welcome to you all for being here. Actually, summer doesn't start until June 20th, so I think it's just symptomatic of our crazy year that we started our summer series in the spring. And I think that the flexibility that we're all trying to do today is pretty amazing in these, as our governor would say, uncharted and uncertain times. So before I get started, in case you haven't heard the news, I just wanted to share with you, I'm going to be retiring shortly, and the lady who just introduced me, Tasha Davenport, our Deputy Executive Director and Chief Operations Officer, will be the new Executive Director and CEO of CASBO starting August 1st. And I'm so proud of her and excited for the opportunity, and it's been fabulous at CASBO. I am going on to do some other things that I want to do before I get too old to do them. I guess that would be the best way to say them. So good news for CASBO. We're in great hands. We have a great staff. We have great members. Everything is moving forward, and I think we are placed quite well to address all the challenges that we're about to. Well, my honor this morning is to introduce the people who are serving on our panel, and I'm going to ask them to introduce themselves to you. We have tried in our summer series to put people together who will be the right people to give you the right information. So joining us from our friends at Fagen Friedman Fulfrost, we have Kelley Owens, who is a partner with them, and a regular and a favorite of our summer series and just a great friend to all of us in public education is Mike Fine. So it's always wonderful to have FCMAT with us. I always say it's wonderful when you invite FCMAT. It's not so wonderful when they invite themselves, right, Mike? And also you've met Tasha and Sarah, who will be helping with the rest of it. So I wanted to speak about this topic for just a second. Because we are all so worried, and I think that's exactly the right word, I know that there are chief business officials all over who are totally losing sleep, hair, probably aging quickly as they're trying to figure out how to navigate what's ahead. And one of the things that we all do when we get into a financial crisis is we try to look at our assets, and we also look at our liabilities. But when we look at our assets, we try to make a determination if they can help us weather the storm and weather what's in front of us. So this topic today, because I think there are sometimes that governing boards will say, oh, well, we're fine, let's just get rid of this or let's do that. So this is a topic and that I think is just so timely. And it's also a topic that we just need to be really strategic about how we go about doing this so that we're doing it for the right reasons for the long term and not for a short-term fix to a long-term situation. So with that being said, I will turn it over to our panel and welcome.
Thank you so much. And my name is Kelley Owens. I am a partner at Fagen Friedman Fulfrost, and I'm co-chair of the Business Facilities and Real Estate Practice Group. And I'm thrilled today to be joined by Mike Fine, who many of you already know, and I'll leave it to Mike to introduce himself and kick us off with the slides. Thanks, Mike.
Thank you, Kelley. Always my pleasure to partner up with F3 and certainly our friends and colleagues at CASBO. As Molly introduced the topic, this is a topic on sell sites. We're not talking about the very painful process that you have to go through leading up to this if it's a current operating site, right? Many of us have been through that painful process of closing a site. That's not really our topic today. And as Molly indicated, while we have a lot of angst about what's the budget's going to look like, I also remind us that our schools have been around for decades. They'll be needed in the decades ahead. And so the whole decision process about taking a piece of public property and putting it out on the market and having it change hands is a very difficult conversation for your community to have. Kelley's the expert here. She's going to walk you through the steps of that sell process or potentially lease process, and I'll add some color commentary, I guess, as she goes through this. But I do want to start out with an update on the state budget. I am expecting a final budget here fairly soon. Negotiations continue between the legislature and the governor. And what we have right now, I think most of you understand, is we have two approaches to this first year of budget difficulties. We have the May revision or governor's approach, which is a combination of program cuts and borrowing or deferrals, apportionment deferrals, acknowledging that this isn't going to be a one-year issue. This is going to be an issue that we're going to be faced with this distress and economic downturn as we for the next several years. We have the legislature's issue, which focuses a little bit more on the short term and doesn't make program cuts for the most part on the K-12 side of the house. They do borrow more so than the governor proposes to borrow with apportionment deferrals, and that number can escalate up depending on federal funding. And so there's also not only negotiations going around about the dollars, but there's negotiations going about the language that implements the philosophical approach and any new requirements, or as this topic lends itself to, any flexibility in existing requirements as we move through. Sarah, my screen, there we go. Thank you. I just covered that, so we'll go to the next one. As you all know from news reports, the legislature did pass their version of the budget this past Monday. Negotiations will continue over the next 12 days. I actually believe that they'll be much quicker than that, is my sense. I know that the two legislative and administrative teams have been working through details nonstop for actually several weeks. And so it's a matter of getting through that. They have non-K-12 issues to solve as well. This isn't only about education. They've got state employee compensation issues to work through. They've got all other state funded programs and details to work through. We don't expect the governor, this is an approach issue, a process issue. We don't expect the governor necessarily to veto what was passed on Monday. What we expect right now is that there'll be a second budget bill that will have adjustments in it that, for lack of a better word, corrects or adjusts the first one to reflect whatever deal is reached. And then once that's done, trailer bill language that reflects the mutual agreements will also be developed. I would guess that second budget bill, or budget bill junior, if you will, whatever label you want to put on it, and the trailer bill will come together for the most part. And I don't expect the governor to take any action, maybe some action on a couple bills that have already been passed that deal with this fiscal year, the current fiscal year, as opposed to next. There's no real disagreement over those, but I don't expect the governor to take action on either the budget bill that's already been passed, the second budget bill, or the trailer bill language until everything's on his desk and there's complete agreement around everything. So with that, Kelley, I'll turn it back to you and talk about surplus property and the sale of such.
All right, thanks, Mike. And my co-panelists set this up perfectly because of the tough times we're in. And Mike and I have teamed up on a couple other webinars in the spring since the shutdown happened and since we're dealing with this unprecedented time. And really our goal has been to help with a little bit of certainty in a really uncertain time. And that's continues to be our goal with this issue. And as we've already talked about, surplus property and school district property are one of the biggest assets that school districts have. And there's potential there to maximize value and serve as a potential revenue generator, which can be one tool that you have as you navigate these waters. And so really our goal today is to hit on 3 different topics. We're going to start out with some new flexibility that we anticipate will come. We can't say for sure given the budget situation, but we'll start there. And then we'll move on to a little bit more of what we know for sure. What are some existing restrictions and requirements on your surplus property that you can be thinking about now when you're getting questions from your board, when you're getting questions from your community? And also, we're going to share some best practices and considerations to think about as you navigate this process, not just anytime, but particularly during this time of COVID. So if we skip forward just a moment, we'll talk about where we are now. So here's the existing law, and we'll get into a few points in the law that might be coming. And with all of this, again, we want to give you the guidance so that you can think about things now, plan now, and potentially take some actions now so that you are ready when the budget picture is a bit clearer and you know what's going to be best for your district. So what's the existing law when we talk about the sale of surplus property? Well, you find it in Education Code 17462, and this is what many of you CBOs and business folks are familiar with, is the general guidance that the sale of surplus property, those proceeds should go back to your facilities costs, mainly your capital outlay costs, your long-term maintenance costs. Those are typically the costs that you don't expect to recur within 5 years. Though that is your general rule, and that's what you're familiar with. And as we get into this time period, many CBOs we talk to still may have that need for facilities costs and putting those sale proceeds into that bucket still to move dollars around for other purposes. There is a very narrow exception in the existing law where you can put sale revenue and lease with revenue from leases with option to purchase. We'll get into what that means in a little bit, but you can deposit that money in the general fund only if you meet very narrow circumstances and restrictions. And many districts, in our experience, we have not seen many districts use this exception right now or in the past because it's a really high bar to meet. One of which of the standards being you have to make a showing to the state allocation board that you have no anticipated need for school site funding or construction needs for the next 10 years. And the CBOs that I talk to, I don't think many of you all could say that. And so it's really not going to be the ideal exception to be able to use your general fund money. But if we jump to the next slide, we do have a new option that we think is coming in the final trailer bill language of the budget. Now, again, you'll hear me say this over and over again, because of the current uncertainty with the budget, we cannot be sure that this flexibility is going to be here in the final version. But here's what we know so far, and here's what we know right now. When it comes to the sale of surplus property, in both the governor's May revise and in floor reports from the legislature, we see this particular language. So they talk about, and it's consistent across what we see so far. And it says you can use, so they're going to allow local education agencies to use proceeds from the sale of surplus property for one-time general fund purposes. So that caught our attention because that could promise additional flexibility. The other place where we see this show up is in, after the governor released the May revise, we did see some draft proposed amendment language that was pulled into a trailer bill. And again, it is a draft version. We're not clear whether this will be the final version, but it does give us an idea of where we could see this language show up. And that would be in Education Code 17463.7. We'll talk about a prior version of this bill that came up back in the last economic downturn, and where there's some differences. But again, the language we're seeing, we can only make some predictions about what that might look like, but we want to at least let you know about it so you can keep an eye on what's coming and be ready to speak to your boards and your communities about this option, because it does still come with what we anticipate are some restrictions. So let's look a little bit more about what we know about this proposed flexibility, and really want to focus on the one-time general fund purpose. Now, this California Code of Regs is in existing law. It's often used in conjunction with that very first code section that I quoted to you in terms of the exception to the rule and how you can use these funds in the general fund. And what this regulation states and defines is one-time expenditures are really quite narrow. And I want to focus in on two key parts of this language. One-time expenditures are going to mean costs that do not commit the school district to future costs, to future ongoing obligations. So things that recur year after year. And the other key language here is, in using sale proceeds for your general fund, you're going to be restricted to not using those proceeds, even under this exception, not using those proceeds for ongoing expenditures. So we'll get into a few examples to illustrate what this looks like, but really the definition of ongoing expenditures is mainly around things like salaries, benefits, because those are recurring costs. Those will not be part of the scope of what you could use these sale proceeds for. So on the next slide, we'll get into a little bit more examples of what could be used. And this comes from both reviewing the draft amendment language that we're seeing that could come with this flexibility, but it also comes with prior practice, what we saw other districts use back in 2009, 2011, when they sought to put some of their sale proceeds into general fund. The first few are things we think might be helpful right now. So things such as reopening costs or technology upgrades. Back when this was used in the prior version of the statute, some districts took the proceeds from the sale of their property and they put it into what was called a fiscal stabilization fund. And they used this funding for things like education supplies, technology. So we think as you look towards the fall and reopening, there's a number of different uses that have never been around before and will likely still fall within one-time uses to get you ready to reopen schools that could fall within this one-time general fund purpose. In addition, technology upgrades to be able to continue distance learning where necessary may be another potential cost. And again, focus on that one-time allocation. The other one that we've seen used very commonly in the past by districts is they will take a significant chunk of money from their sales of property and they will put it in, fund their post-employment benefits. And that is an allowable cost at least under existing law and the existing regulations, but we anticipate those regulations should track similar to what they did in the past. Again, just to point out, things that are not one-time expenditures. So even if you do seek this flexibility, what you won't be able to use under this definition are for your ongoing expenditures. Things like salaries and permanent raises, because that could have an ongoing impact and also have an ongoing impact on your pension liability. And so those items would fall outside the scope of where we see this law heading. I do want to mention that we are in contact with State Allocation Board. Those folks are great, and they did, and we didn't tell them to say this, but they did say, you know, there's still going to be some gray area issues as how you can use this money, and to contact your attorney if you would need, and that's typically what they refer the school districts to do before they navigate this entire process in trying to use these funds for general fund use. I'm just going to pause here right now because I know Mike has some great insights on where the law was and where it may be going. So Mike, anything to add here?
Kelley, a couple things. One is related to post-employment benefits. I think some would view those as recurring expenses, right? But the concept here is that when you've set up a trust and you're trying to build that trust up to the actuarial value of those post-employment benefits, that contributions to that trust would be discretionary and viewed as one time. Although it may happen multiple times, it's not a regular recurring expense type of thing. And it's a great use of any one-time dollars. We even argued years ago when we had the discretionary one-time dollars that happened year after year after year, that per ADA discretionary amount, building up the OPEB trust was a great use of those funds to help you in the future. So just a point of clarification there. There are a few changes, and as Kelley's going to get into, one of those is to add the lease with the option to purchase between the flexibility on this topic that we received in the Great Recession and the flexibility that is now proposed. And so that's really to expand kind of the view out there of opportunity of what districts can do with property. Not necessarily sell it, but enter into some type of agreement, partnership agreement and continue to retain ownership for the long term, those kinds of things. And so grateful to the administration for looking at it a little with a little wider lens here that would be helpful to school districts. One of the districts that we're in right now, working with and have been for a number of years, has 22 acres that it's entering into a lease with the option to buy provisions. And over the life of the deal, as it's currently been bid, is worth over $100 million to them. And so you start to see that these have the potential to have big positive financial impacts. And in that case, they won't ultimately lose ownership of the property. Assuming they don't exercise the option to purchase, right? And so, and Kelley, as I said, will get into that a little bit more.
Thank you, Mike. And we do appreciate this additional flexibility, which we'll get to a little bit more detail on the next slide. So based on the draft may revise language, and again, I'm saying it, I'm repeating myself, it's not final, but what we are seeing so far is some anticipated requirements so you can get ready for these things if this is an option for your district. So one of the key parts of this is, well, actually a few parts which I'll highlight will factor in when you're looking at your properties. Mike brought up a great example of how you may want to use your properties and start talking about the logistics in either sale or lease, which we'll get into, but that may be informed by what ends up in this bill if a general fund use is on your radar. And so what we anticipate is definitely a requirement that you will have to provide some documentation to the state allocation board in order to use these funds for general fund purposes. And that will be a step that you have to take before that money is shifted over. So a bit of a timing element there when you consider when these proceeds may become available versus when you're going to be submitting your documentation. We do anticipate that one of the requirements will be if you are allocating money towards general fund, that your hardship assistance from the state would be reduced by an equal amount. And one of the key parts that I think you could potentially start planning for now is along with your documentation or as part of your documentation that you submit to SAB for this flexibility, you will be required to submit a plan for the expenditure of funds, showing not just the use that you plan to allocate the funds to, but also the source of the revenue itself. So that really goes back to, as we'll get into, the nature of the property that you are going to sell or lease with option to purchase, and really knowing what your plan is. So just a practice tip here, this is not something that just a CBO would have to submit. It is what our best practice is and what we've seen in the past is to have the board adopt these findings, the required findings that will be laid out as part of this new flexibility via a board resolution. And when the board makes those findings, we typically recommend that your plan for the expenditure of these proceeds be an attachment to your resolution. And we do have sample resolutions and plans that we've assisted districts in the past, so you wouldn't necessarily need to start from scratch if this becomes an option to you. But particularly on the last part, I just wanted to mention what we anticipate as well is you're not just going to have to show the specific use of proceeds, but possibly go a step further in your findings to make sure that you explain why the use of the funds, the proposed use, is not going to create an ongoing obligation. And I believe this is particularly important in this round because we are dealing with such uncertain times and such unknowns that I think it's the SAB will likely take a position that they want to be clear that this, even if this situation is extended over years, that we're not creating an ongoing obligation with the way that we're using our funding. So I think that's the anticipated requirements. And just to illustrate this a little bit further, we can go to the next slide. And I know there's a few CBOs and business folks on the line that probably remember when the prior version of this ed code was in effect. This was a time period where we did see an uptick in the sale of properties, also leases with option to purchase, but more so in the sale because of this flexibility coming in. So you may recall this older version. Now this older version is no longer in effect. So we are now looking towards this pending bill that would revitalize Education Code 17463.7 in a little bit different form. So Mike already pointed out a pretty significant difference, and one that we're appreciative of is it looks like the language that could be adopted, that's slated right now to be adopted, would allow districts to use the proceeds from both a sale of property or a lease with option to purchase. And I know we've been throwing that term around quite often, and so I want to make sure we're clear on what that means, because you have many leases out there for school district property, but here the lease would have to contain a specific term that allows the entity that you're leasing to purchase the property at some point. So it becomes very critical how you write your leases and knowing what is in your leases to draw that very important distinction about whether it's just a lease or a lease with option to purchase. But we do anticipate some additional flexibility there, as Mike pointed out. The other things we're seeing is some of the bigger restrictions that we saw in the 2009 version in terms of the fiscal consequences of using this money. We don't think there'll be a need to prove that you have no major deferred maintenance needs. There were quite a few hurdles that you would have to show in the past to use this money. And really, again, this language is still up in the air, but the key takeaway here is that we anticipate slightly more flexibility than in 2009. And so the business folks on the line who remember looking at this bill and thinking, nope, that's not going to work for my district, it may be worth another look, assuming this is passed, to see if it's going to work in this particular scenario. Just another tool in your toolkit to potentially generate some additional revenue. So I know that leaves us with a little bit of uncertainty because the budget language is not final. So our plan, and we're going to work with our co-panelists on this, but our plan, at least from F3, is to, once the bill language is final, to release a newsflash on this subject that provides more definitive guidance once we know exactly what the bill says and once that bill is final. So that should be coming closer to the beginning of July, we think, when everything is supposedly finalized. So I just wanted to pause here before we jump into more of the general surplus property section to see, Mike, if you have any further comments on this.
Kelley, the only comment I have is we really haven't talked about any restrictions upon the proceeds themselves, and I don't mean the use, but the basic proceeds. This applies when the property in question was purchased with 100% local funds. And there are provisions, as there were in 2009, there are provisions now that if those local funds were general obligation bonds, how that needs to be prorated and handled as opposed to put in the general fund, actually not just GO bonds, but also developer fees. So the idea here is that any GO bonds or developer fees that were used in the original procurement process, those in essence have to be returned to those respective programs and spent in a nature, the assumption would be spent in a nature relative to what those programs are. So this would be property that you purchased maybe with a COP and you used your general fund to pay the debt service on the COP or the like, right? And so from that standpoint, it does narrow down. Obviously, property purchase with state funds, there's a whole body of law with regard to negotiating the return of those funds to the state, and even the process to go through declaring surplus and selling that property. So just as a matter of clarity here.
Mm-hmm. Thank you, Mike. And that's really going to be why you want to know your properties well, and you want to know the source of the funds that were used to purchase the property, because depending on that one fact, it could dictate how you're going to treat this revenue, as Mike so accurately points out. So with that, we can get into a little bit more of the general guidance that we have for you on surplus property. And we start right where we're just talking already, is your asset management. Really knowing, as we've already discussed, the assets, your real property in a district are some of the most valuable resources. And not just for selling it off and generating the revenue, but really knowing for each property how to maximize that value. And whether it's as a continued school site, whether it's a property that you lease, whether it's a property that's never been developed that you want to sell, really knowing what the district has is a very critical step. And it's actually something that districts can start now, even with this time of uncertainty in the budget. There's many steps in this process, which we'll get into, that districts can start taking at this moment, so that when it comes time to make the tough decisions, you're ready. Questions that you can start asking are, if the district is looking at this as a potential revenue generator for surplus property, what properties to sell, what properties to lease, when to begin. And as we're already alluding to, it's probably sooner than you think. And also who to involve, your team in this process. And as someone who often comes into existing district teams, it is so wonderful to have a great team around the CBO and business people in making what can be at times very tough decisions. So let's get into a little bit of asset management. So again, what things can you be thinking about right now or over the summer, so that if this becomes an option for you, whether for facilities, cost, capital outlay, or for some of the flexibility we're talking about, what can you be doing right now so that you're ready? First thing is, we definitely recommend a property audit. It can be a more formal audit or asset management done by an outside consultant, or it can be simply gathering the details of each of your properties. And what do we mean by that? What are some of the things you're going to be looking for? Particularly looking at surplus property that may go into your asset management process. How were these properties acquired? What funds were used? What year was it acquired? Were there any rights left with the prior owner with the property? And another key question is, how has this property been used in the past? So Mike alluded to this earlier, and if it's an existing school site, you're going to be looking at not just the process we're going to talk about today, but a whole nother process involved with school closures, which is tough and politically charged. And so it really is outside the scope of the presentation today. But one element we'll talk about could be helpful, even if that's the case and it's needed there. Also, things like the condition and adequacy of your existing facilities. So if you've already closed a school site, for example, and that school site is deteriorating or might have some asbestos contamination, things like that, that's going to be a factor in what you do with the property down the road. It also might be a factor in whether or not you preserve the property as is, or you conduct demolition on the property. Also, especially getting into what we've seen in the last few years, demographic trends. Are you in declining enrollment areas? Where you could potentially be declining enrollment in some areas of your district, and on the other side of your community, you're increasing. And so really knowing where your demographic trends are and headed is going to be very helpful. And that, you know, that's a good reminder here of it may require other folks in your cabinet besides just the business people to start weighing in on these types of things. Also current and future needs. And we know right now, as we look towards reopening procedures, we're not exactly sure what the classroom is going to look like right now. And what we know is it's going to probably going to look quite different. And we understand that if the recommendations are for social distancing within the classroom, all of a sudden your enrollment capacities in each classroom might be very different than they used to be. And you know, in talking with a CBO who's been out in the field for a while, they were reminded of, they mentioned in 1996, when the ratios of classrooms all of a sudden went to 20-1. And they recalled districts scrambling for portables and teachers and elements like that to make sure they could meet that, which we know that's no longer a requirement, but that was a similar situation they thought of, where all of a sudden your facilities are going to be used differently. And so as you look at each of your properties, it might have to be through this new lens of school reopening. So a few other considerations on the next slide we can talk about. And we've already covered in general when to begin, and we recommend now if this is going to be an option for you. But what does that mean? What things could you do as you get to know your properties a little bit better and you start to look at how they may be maximized in value? One thing we often recommend as soon as we come into a particular transaction is ask if there's been an appraisal done of the property. And this just helps, especially if you're weighing the options of whether to sell or lease. The dollar figures are going to be very important in this discussion. And this is often a question you'll get from your board members too, is if we do all of this, if we go through this whole process, what is the potential end result? And an appraisal will at least help you start the conversation of, here's the values that we anticipate, and which could be subject to change based on a number of factors. Another thing we recommend is really knowing your properties means knowing the history of your property and what restrictions or other elements might be on your property. And so something like a preliminary title report will give you that. It'll give you all of the documents that are recorded on your property and have been recorded over time. It'll confirm the ownership of the property. You'll be surprised. Sometimes we'll get older properties and it's in the name of a school district that doesn't even exist anymore. And that is a good thing to know early on in the process. And so both on the appraisal front and preliminary title report, it may be somewhat of investment up front, but it gives you some really critical information that you can start assessing now to have answers for your board and your community later. As far as who to involve, that's another really important part of this process. And your team is your team. I think each person, each CBO is going to have a different assessment of what team they want, depending on the type of properties at issue, depending on some of the concerns maybe in the community, potential buyers. That's really going to depend on the situation, but it's important to start thinking about now. Another key element of it are two very important components to all of this that we recommend you consider as your team is your 7-Eleven committee, which we'll get into in a little bit, and who are your community stakeholders that are going to provide you with honest but constructive advice on the properties that you might be putting up for consideration. And so we'll get into both of those elements as well. let's
Kelley,
talk about the 7-Eleven committee first. Oh, Mike?
I just want to emphasize what you said about the appraisal, doing one early, but it's also important to work with an appraiser that can look at various uses of the property so that you can value what potential different uses and zoning may be. And you're going to cover local zoning considerations in a minute here, but those become important because those add significant time, cost, adding specialists to the team to work through those kinds of issues with your municipality or your local land use folks. But you want to do that with some knowledge that if I rezone from public facilities to low density residential or high density residential, these are the dollar differences I'm talking about, and is it worth it or not, right? So not just an appraisal of current property, but have them look at options that would help inform you of how to maximize your value.
Absolutely. And if we jump to the next slide, there's just an overview of a few considerations, just like Mike pointed out. Making certain assumptions about what you'll be able to do with your property. Land use and the zoning of the property that a district owns is a big factor, because to change that zoning takes an entirely separate process that's often up to another public entity such as a city or county. And it also adds time to the process, time and money to the process. And so knowing how your property is currently zoned will be part of that appraisal process that's incredibly valuable. These are some other things to think about, especially for business people and CBOs who are getting lots of questions from their board and their community. As we alluded to earlier, it's not just as easy as, oh, well, let's sell some of our property. You know, we'll generate that money really quick, because in many people's minds, they think about that really quick residential sale escrow process. It is definitely a different process than that. And there's lots of considerations that go into what you're going to do with your surplus property. One of the biggest impacts is the formation of your 7-Eleven committee, as we'll get into. You also have to, especially if you're selling or leasing with option to purchase, the law requires that districts offer this property to other public entities and other organizations before it can even go out to regular sale. You also need to be thinking about how you're going to sell. Traditional process is, once you get through the statutory requirements, a public bid, which we'll describe. But there's also a waiver process that might be more fitting in certain circumstances. And again, you're going to be confronted with, if you have a valuable property, what to do with it, and whether you sell or lease, or we'll talk about some other solutions towards the end. But let's get into 7-Eleven, because in our experience, this is one, when we're talking about the sale or lease of property, this is one of the most important elements, but it's also one that the full time and extent of it and some best practices are not necessarily communicated up front and to our districts. And so we wanted to share some of this information with you. And you may be familiar with the 7-Eleven committee, but I think we're definitely operating in a new world. So we'll try to point out a few things that we're seeing more lately. And so here with Education Code 17388, a key factor is a 7-Eleven committee needs to be appointed by the board and convened prior to the sale or lease of surplus real property. So it's a critical step. There are some narrow exceptions that we assist districts with, but this is the general rule. And again, many of you know this. Why is it called 7-Eleven committee? It needs to be at least 7, but no more than 11 members. And if you look in the Ed Code, there are some specific people or roles that your 7-Eleven committee must have on it. Things like a person from your unions, your union representative, a parent in your community, representatives of other public entities, someone from the business community, and someone with knowledge of real estate. And really the Education Code has given us a gift here, because I've seen it in practice. This, if you assemble this team right, it is a tremendous asset to have for this property process. So just as a quick example, we had a recent 7-Eleven committee that we actually held over Zoom meetings, because they are subject to the Brown Act, but you're allowed to do that with proper noticing. And we had a committee member that, even in this tough time of the shutdowns and everybody being at home, he had such great connections with parent groups and community members that he was still able to use his relationships to get us the feedback that we needed as we made some tough decisions about property. And that was somebody that had been pretty outspoken in the community, and that we might have been a little bit resistant to have in the 7-Eleven. But he ended up being such a tremendous resource because he was honest but yet constructive with what the feedback he was giving. And that was incredibly valuable. And so I think that's a key factor of 7-Eleven committee. Sometimes it may feel a little bit inconvenient to have to go through the process, but we try to make it as efficient as possible to get you towards the end, the ultimate goal, which is declaring the property surplus. But there's just such value to it. The other thing I would want to mention is that it's also something you could start now. So even if you don't know exactly what you're going to do, and you may have 2 properties, you may have 8 properties, we've seen the best districts, as far as 7-Eleven committee use, had a committee that was very thoughtfully formed and up and running, and the board was able to give them properties as they went. So the board would pass a new resolution adding properties to their review. So it made it a lot more efficient and easy to navigate the process, because that committee was already up and running. They were already trained and familiar with the process. So that's one recommendation you could think about if you think you're going to have surplus property decisions to make. Just quickly on the next slide, what this committee is going to be doing. Many of you are probably familiar with their process, but they're essentially doing what you would want the district to be doing anyway, just with community help and some additional feedback. And they're looking at, where are your surplus properties, the properties you're looking at, including potential school closures. That's something we recommend, whether or not there is enough space, classroom space in the district to be able to close a school or be able to sell or lease a property. And so the committee, ultimately, their goal is to create a report making a finding whether they believe the property is surplus to the educational needs of the district, and they recommend some uses of that property. So these reports can take many forms. Sometimes 7-Eleven committees want to go very broad and defer to the district on their recommendations. Sometimes, based on community feedback, they have a particular recommendation in mind that they pass along through the report. But the key thing to remember is it is a very valuable process, but the report is simply a recommendation for what the board, the governing board of the district, would ultimately do. So if we jump to the next slide, and I think I touched on this because it's such a critical point, is your 7-Eleven committee can be a benefit to this process, because it acts as the microphone to your community and helps gather that input. And particularly now, with things shut down, maybe still difficult to get to meetings or participate in meetings, your 7-Eleven committee will hopefully magnify whatever the concerns are and collect whatever the concerns are in the community, so that they can provide those recommendations to the district board. And it also is just good business practice, because they are going to aid the district in using the property responsibly and making sure that the decisions the district are making honors both the fiscal and educational needs of the district. So let's say your 7-Eleven committee goes through this process. They make their finding that the property at issue should be declared surplus. What are your next steps? Key next steps are, the board then takes that report and in open session decides whether to declare that property surplus on behalf of the district. And it does need to be declared surplus by a majority vote. And we highly recommend via a board resolution that makes the various findings that you're going to need for that particular scenario. And that can depend on how you're going to use the property. It's going to depend on what education codes and government codes may apply. But the board resolution is really a helpful device to wrap that all up. The next step, once that happens, is there are some additional time requirements and notice requirements for offering the property to other public entities and other agencies via things like notice letters, newspaper publications. So what we like to do, especially because we're trying to keep the process efficient, is when we know these matters are going to the governing board and we have a good feel for where that decision might head, we will try to have templates of these items ready to go so that those can be sent out quickly. But still, I think you're looking at between 60 to 90 days additional time in your process to make sure you get through these offers. Just a couple of things we wanted to touch on quickly on the next slide, because these are questions we're continuing to get as part of the considerations of surplus property. And so one thing we wanted to point out is there are some new laws governing affordable housing offers, and there are some new laws governing workforce housing that school districts need to be looking at. Now, the one for affordable housing that came into effect on January 1st of 2020 expands the requirements for who a public entity needs to offer their property to, and it builds in a lot of affordable housing entities. But the interesting part is if you read that statute, we think they were trying to help out school districts just a little bit, because they basically say, if you go through the 7-Eleven committee process, or if you're selling your property to another public entity, a lot of these rules, these new affordable housing rules, your districts will be exempt from. So it's important to look at that new language critically in light of what property you're talking about. Another aspect is the new workforce housing laws seem to relax some of the offer process and try to make it a little bit easier, that if a district is wanting to develop workforce housing for its teachers or its staff members, that it looks like the legislature is trying to remove a lot of the hurdles to doing that and making a more streamlined process. So if that's an option for your district, then certainly recommend you work with your attorney to see what you might not have to go through in order to sell the property. The other one that continues to come up is charter school issues. So we often have board members still asking our CBOs, well, if we sell this property, won't we have to give it to a charter school first? And that's based on a very specific law that actually expired, I believe, back in 2016. There's been efforts to renew it, to still require districts to offer a particular surplus property to charters, but those have not been enacted. So as of right now, that requirement is expired and is no longer a requirement. But what is still somewhat of a requirement, at least as it comes to charters, is your more general Prop 39 obligation. So you still have to offer facilities to a charter school that requests it, but as opposed to this prior more specific law, you don't need to have that particular property offered first as a priority order. So that's a pretty big difference that that we're often continuing to point out, because it did used to be in the law.
Kelly,
So
quickly.
Yes.
If I could pause you for a second, we've gotten a few questions in terms of if we know if the flexibility will apply to proceeds from previous sales of property, or is this only applying to future sales, as some districts are sitting on cash from recent property sales over the last couple of years. Will these dollars be included in this new flexibility, or are we just talking about future sales?
We don't know for sure until we see the actual language. And the key step is going to be that provision we shared with you is there has to be documentation submitted to SAB before that money can be used for that purpose. And so that's really the area in the requirements that we'll want to focus with that type of question. And without knowing exactly what that provision looks like yet, it's difficult to tell, but it's certainly something to look at, because if you have money waiting and you haven't used it for any purpose yet, that language requiring simply to submit documentation before you use it could be the hook to be able to do that with existing money. Mike, anything to add there?
Sorry. No, nothing to add. I agree. I think it's a little gray here, but I think the key, this section doesn't deal with the sell. You've already completed that. This section deals with the use of the proceeds. And to Kelly's point, then you work through that. And so I can tell you, as somebody involved in crafting the section, it wasn't our intent to limit that, but that also wasn't what we were focused on at the time we crafted it. That probably just adds more confusion around what the intent was, but work with your attorneys and I think you'll get to where you need to be.
Mm-hmm. So just to wrap up on a couple key points here, the public bid process, many of you are familiar with, so we're not going to go into detail there. But again, it's another element that if you want to sell or lease your property with option to purchase, there is a public bid process that is required under the Ed Code. There is an opportunity to get a waiver from the state of certain components of that process, but again, it takes some time to do that. So if you're hearing a common theme of additional time, we just, again, if these are options for you, start early and start assessing the potential for either a waiver or a public bid. As far as your purchase and sale agreement and lease agreement, we only put this here as a reminder of they're still contracts. So that is your ultimate goal here if you're looking to sell or lease property. But contracts that you used maybe 2 or 3 years ago may need to be looked at again in light of coronavirus, because we're seeing out in the field things like delays in escrow process, things like delays in title, release of funds to close. You want to have a little bit more flexibility for school districts in navigating the closing process, because there's just some uncertainty there. And again, they're both contracts that we highly encourage you to look at again through this new lens. And then just on the final 2 slides, along with Mike, we wanted to revisit this decision that you might be confronted with. You have surplus property, but there's some differing opinions on how to use that. And there's a couple things in a framework we wanted to give you to navigate that with your boards and your communities when folks are trying to decide what to do. In terms of a sale, the biggest drawbacks are if you sell a property, once it's gone, it's gone. And as you've heard, and we've gone through really quickly, there is a complex procedural process to the sale. And whether that's a public bid or a waiver and a 7-Eleven committee, that's a process that you want to have in mind when you're making your factors. And then also, as Mike brought up, maximizing the value of a sale of your property may require more time. So if you're going to rezone it and sell it to, for example, a developer who needs to get a ton of entitlements before they're willing to close, that may maximize the value of the property, but it may push out your timelines. And in those situations, we try to craft our contracts to make sure that whoever's buying the property it has to submit different deposits or maintain, hit certain timeline requirements. But again, that's part of sale process is knowing that. And then benefits, obviously a substantial source of revenue. California property is incredibly valuable. So you could, it could be a revenue generator to sell. But there's, and again, as opposed to a lease, you're not going to have landlord duties. You're not going to have ongoing liability for the property once you sell, and you're not going to need to renegotiate a lease every year. And then just let's compare that quickly to a lease on the next slide. With a lease, whether it's a regular lease or a lease with option to purchase, you're going to have potential property maintenance costs. Some of that can be contracted away, but you are the manager of that property still. And being a district landlord may not be what you set out to do as a CBO. So that's a consideration. And you usually have some less upfront revenue. Benefits of leases with option to purchase, as Mike talked about, it's a continued revenue stream. You're maintaining ownership of the property, which has its own benefits there. So just some factors to think about. And even if sale or lease is not the ideal scenario, there's many, many other tools that you can look to with counsel, with your advisors. And on the last slide, you'll see there's just a list of options. We don't need to go into those in great detail, but the tail doesn't end with just sale or lease. Things like property exchanges actually get you out of a lot of the requirements we talked about today. And if you have property in one area of the district, you don't need increasing enrollment in another area of the district. That's been a beautiful device in order to just simply exchange property with another entity. And you can either do that via property or property plus some cash value. That seems to have worked well in the past and may work even better in this time where liquidity may be an issue. But I'll leave it at that and open it up to anything else Mike wants to add and any questions we can squeeze in. Thank you.
We have one more question and then we'll defer people to send us an email and let us, and I'll put the email address where they could send us emails and we'll relay that to you both. But the last question I got is, can you discuss AB 1157 and how that might affect the property being declared excess? Is a 7-Eleven required if a ground lease is for a teacher or school district employee housing? And you're on mute, Kelley.
Thank you. That happens once a Skype or Zoom. So I believe that is one of the ones that that allows the district to not elect to appoint a 7-Eleven committee if you are going to use the property for employee housing. That's one of the exceptions that we were talking about with that new law. And I don't know the exact parameters of what does and doesn't apply, but I know at least it doesn't require you to go through the 7-Eleven, and I believe it may relieve you from other the statutory offer requirements. So if you are looking at affordable housing and particularly under 1157, that is now an incredibly good device to fast track your process. And of course, looking at that statute in detail would be my best advice as you navigate it to make sure your board resolutions and board findings line up with the requirements of that bill.
Mike, would you like to add anything?
No, I'm good, sir. Thank you.
Well, thank you so much, Kelley and Mike, for joining us today. Next Wednesday, June 25th at 1 p.m. Our next session will be with the California Legislative Analyst's Office, Edgar Cavall, the Deputy Legislative Analyst, discussing, hopefully by then we'll have more details on the state budget. So look forward to that coming out shortly. Thank you so much for your time. And if you have questions, please email me and we will get those answered. Thank you.
Thank you.
Thank you all.